Hello and welcome to What to Expect in 2021, the key issues employers need to be aware of. I'm Hayley Cray and I'm delighted to be joined by my senior team, Matt Cameron, Laura Hillman and Dee Fairbairn, in relation to addressing the hot topics of things that we are going to need to know in 2021. Before I begin, however, I'd like to acknowledge the traditional owners on the land in which this event is taking place, the Turrbal and Jaguar peoples, and by paying my respects to their elders, past, present and emerging. I'd also like to flag that there's a Q&A feature on your screen at the right-hand side. If you want to send through your questions, I will do my best as they arise, and we will try and ensure that we can answer them, if not during the presentation at the end. It's hard to begin to actually think that we're about a quarter of the way through 2021, and I know many of us are still trying to get over what was 2020. There are some really important lessons and legacy items that remain with us from 2020, some of those are on the slides. How could we forget the High Court pronouncement in Mondelez that personal leave is 7.6 hours of a day, and the calculation methodology that spent many times of employers looking at their leave accruals and communication of how to account for leave in their time and wages records. In addition to this, we had the enormous focus of stand down and lawful stand down directions and accessing leave during stand down. Remembering that some leave, annual leave and long service leave, is acceptable to access, but the question which Qantas determined and the court maintained that personal leave was not an entitlement being able to be accessed during stand down. WorkPack and Rosato, again a key feature of many employers scrambling to understand and put in place appropriate arrangements for casual workforces, where the court determined that what many would have expected otherwise would happen, that if you've mischaracterised and misclassified a casual, that a casual would be entitled to payments akin to a full-time employment engagement, including leave. Wage theft. Queensland and Victoria particularly focused on the commencement and introduction of legislation for wage theft, bringing a greater focus on the compliance of underpayments and the personal responsibility within an organisation to address wage compliance. Parental leave. Some have not actually yet caught up with changes in relation to the parental leave requirements, including greater access to flexibilities from the 1st of July 2020, where you could take up to 30 days more of an 18-week entitlement flexibly. Ongoing award reforms, ongoing wage increases, and the focus of compliance matters we will lead in shortly to talk about as a what to watch in 2021. But with the end of JobKeeper coming at the end of this month, the focus on what COVID and a post-COVID world as the Australian economy, albeit within the restrictions of international travel, focuses on meaning for business is still the primary question for many. Keeping up with those ongoing reforms and looking at what business efficiencies, restructuring, and the impact on some employers of a loss of the JobKeeper supplement will mean that there is going to be a heavy focus in terms of both compliance, but also regulatory environments leading to consultation, business efficiency, and restructuring as we move forward. Keeping atop of these reforms becomes important as we look at what will happen in 2021. Ultimately, today we have picked three of the most sought after questions that many of our clients ask us to address. This includes focusing on what will come down the line in terms of the Omnibus Bill and what will pass through legislation in terms of more IR reform. In addition to this, not a day goes past where we're not looking at the impact of the COVID vaccine rollout, who will get it, the timeline in relation to the accessibility in the community, and what it might mean for employers in terms of workplace health and safety directions, safety at work, and the ability of people to remain working from home and or vulnerability in returning to the workplace. Last but certainly not least is the increasing focus on compliance and the never-ending impact of wage theft review and awareness in terms of how employers are addressing those matters. Since promoting this seminar and coming up with those 3 topics, which my team will address with you shortly, it would be remiss of me to fail to mention what seems to be coming first and foremost, at least in the media and in many workplaces, the question of sexual harassment in the workplace. Earlier last month, Safe Work Australia released guidelines in relation to removing risks of sexual harassment in the workplace. The common question asked by many is, how come it is possible that we are continuing to hear about these matters? You may remember last year, the Australian Human Rights Commission released a report in relation to sexual harassment and 55 recommendations to be made in relation to reforms to remove the impact of sexual harassment in the workplace. These focus matters highlight again the need for good policies, good communication, and ensuring that there are transparent procedures in a workplace to deal with sexual harassment. The ongoing focus, particularly during the media at this time, reflects a need for all workplaces to ensure that they are taking steps to minimise the risk of workplace harassment, but as and when they do, that they document and support complaint processes to be dealt with reasonably and appropriately in the workplace. Without any further ado, I'm pleased to hand over to Matt Cameron, who's going to address the Omnibus Bill and IR reform.
Thanks, Heidi. We can just move to the next slide. So the government's Omnibus Bill would make the most significant changes to the Fair Work Act since it was passed in 2009. The bill is currently before the Senate, having passed the House a couple of weeks ago. The government has said that they'll try and get a vote on the bill next week, which is the last sitting week before the May budget sittings for the Senate. So it's really the government's last opportunity to get that issue dealt with before the budget becomes the focus for Parliament and politics as well. So it's unclear whether the bill will actually pass at this stage. Both the Centre Alliance and One Nation, who the government will be relying on to get the bill through, have flagged that they might put some amendments forward. Centre Alliance have said that they want to consult more widely about what those amendments will be. So it's unclear yet whether there will be, I guess, an outcome for the bill next week. But just working through the key parts of the bill, firstly, in relation to casual employees, the bill introduces for the first time a statutory definition of casual employment, which focuses on the offer and acceptance of employment and how that's documented. This is to respond to cases like Workpac and Skene, where an employee engaged as a casual was subsequently found to be a permanent employee because of the conduct of the parties after that initial engagement. And that employee was then found to be entitled to the benefits of permanent employment, such as leave. Now, the bill defines a casual as an employee who is offered employment with no firm advance commitment to continuing and indefinite work according to an agreed pattern of work. The bill makes clear that this is focused on the time when an offer is made, and it's expressly said that you can't take into account any of the subsequent conduct of the parties. The only factors that would be taken into account in determining whether there was no firm advance commitment to work are the ability to elect to offer and accept or reject work, the employee working only as required, the employment being described as casual employment, and whether the person is entitled to a casual loading. So the intention of those amendments is to give certainty to employers that when they employ someone and intend to employ someone as a casual, that they can have some certainty that that's ultimately going to be found to be the case, and that there won't be the same possibility of many years down the track an employee claiming that they were actually engaged as a permanent employee. The bill also introduces a new provision to addressed the full court's decision in Rosato, where it was held that the casual loading couldn't be used to offset leave entitlements that would be payable if a person had incorrectly been classified as a casual employee. So the bill introduces a new provision to allow the casual loading to be used to offset those other entitlements if they're subsequently found to be due. The third element of the bill on casuals is around casual conversion. The bill introduces a new proactive obligation for employers to make an offer to an employee to convert from casual to full-time or part-time employment if the employee's hours could be accommodated as a full-time or part-time engagement. This is similar to the existing casual conversion clauses that are included in many modern awards, but it goes further in imposing a proactive obligation on the employer to actually make the offer or consider the issue rather than just responding to a request that an employee might make to convert. An employer can still refuse to make an offer if there are reasonable grounds, but the employer then has to give the employee a notice explaining those reasonable grounds. So these obligations, I think, will focus a lot more attention on this process, and there's a requirement that an employer also give casuals a notice on commencing their employment that explains how this process will work. So I think it's likely, because of those obligations, there will be a greater understanding of this process and potential for more disputes about it to occur. The bill, in relation to award simplification, introduces a new mechanism to increase flexibility around part-time employment under certain awards. Part-time employees will be able to work additional hours at their ordinary rate of pay rather than being paid for additional hours only at overtime rates. The minimum hours that would need to be guaranteed for part-time employees is 16 per week. So employees could then work up to 38 hours per week, so an additional 22 per week at ordinary rates of pay rather than needing to be paid overtime rates for those hours. There's currently a list of 12 awards that would be subject to those additional hours agreements, but there's also an ability for the government to declare additional awards by regulation. So there's the possibility that the scope of this might expand after it goes through Parliament. In parallel to this, the Commission is also considering an application that's been made to vary the retail industry award to include a similar sort of flexible part-time mechanism with a minimum guaranteed number of hours of 9 per week, so a lower minimum. It's not clear where that will get to and how that might overlap with how this is dealt with in Parliament, but I think it reflects that this concept of a flexible part-time employment that allows an employer to provide additional hours to a part-time employee without then having to pay overtime rates is something that's getting more traction, and we're likely to see more of that. The bill also introduces flexible worker directions for identified awards to give employers the power to direct their employees to undertake different duties and work in different locations. This is really an extension of some of the provisions that were introduced as part of the response to COVID, and these new direction powers will have a life of 2 years from when the bill commences. So they're intended to be a short-term measure to give some more flexibility to employers. In relation to enterprise agreements, the amendments focus on simplifying and streamlining the agreement making and approval process. If the bill's passed, there'll finally be a bit more clarity about when casuals can vote for an enterprise agreement. The bill explains that a casual can vote if they work at any time during the access period for the vote on the agreement. This will still present some difficulties for employers in sectors such as higher education, where casuals are not centrally rostered or supervised on a daily basis, but at least there'll be a clear legal test to apply. At the moment, there's a lot of uncertainty in the decisions from the Fair Work Commission about that issue. The bill also restricts the ability of unions to be involved in enterprise agreement approval processes where they haven't been acting as bargaining representatives during the negotiations. The CFMMEU in particular has had a practice of monitoring the enterprise agreement applications that go to the Commission and seeking to intervene in any applications that it sees that for employers that it might not want their agreement to be approved. It might have concerns about the type of agreement that's been submitted for approval, and the Commission's adopted a practice over the last few years of regularly hearing from unions in those circumstances, even if they weren't involved in the negotiations and don't have a presence in the workplace. So the bill seeks to restrict that. The Commission will be required as well, as far as practicable, to decide applications within 21 days. The Commission itself has raised some concerns about how that will operate, and it's been suggested this might actually be counterproductive, that the Commission might be required to dismiss applications as a result of that time limit if employers can't satisfy it that the agreement meets all of the requirements for approval within that time. So I think that's one issue that might receive a bit more attention in the Senate, and it might be that there are some changes to that aspect of the bill as well. There are also some changes to the Better Off Overall test that were originally proposed in the bill, but they were dropped by the government before the bill went through the House. So those changes that were dropped would have allowed agreements to be approved in broader circumstances than is currently possible, where those agreements didn't pass the Better Off Overall test. That's no longer part of the bill. There are still some changes to the Better Off Overall test that remain. First of all, the Commission, if the bill is passed, must only take into account patterns or kinds of work or types of employment that employees are currently engaged in or are reasonably foreseeable when determining whether they'll be better off under the agreement than under the award. This would mean that the current system of taking into account all hypothetical patterns of work, all theoretical patterns of work that could be worked under an agreement, rather than those that are reasonably foreseeable or likely to be worked or actually worked, that those would no longer need to be taken into account. The Commission as well will be required to give significant weight to the views of the employer, employees and unions as to whether the agreement passes the Better Off Overall test. It'll be interesting to see whether the Commission implements that in the way that it's intended. At the moment, the boot is a very complex exercise, and the Commission very much carries that out itself and doesn't give really very significant weight at all to any party's subjective view about whether the agreement passes the Better Off Overall test or not. So I think that would be a significant change of approach, and it'll be interesting to see how the Commission responds to that. In relation to greenfields agreements, the amendments would allow agreements of up to 8 years to be approved to give industrial stability for major projects, which generally are projects with a value of over $500 million. This is a significant extension to the current timeframe that's possible. For an agreement of 8 years, though, or any agreement that is more than 4 years, the Commission will need to be satisfied that there are annual pay increases provided. So there will need to be a mechanism for rates to be increased over the life of the agreement. In relation to compliance, there'll be a 50% increase in penalties for remuneration-related contraventions. There'll also be a new multiplier system of determining penalties, where if there is, for example, an underpayment by a corporation, then the penalty can be determined by looking at the value of the benefit that the corporation has received from the underpayment, and there'll be a multiplier applied to that. So that could result in much greater penalties than is currently the case. For example, penalties for contraventions are generally going to be nowhere near the scale of the sort of underpayment that we have seen recently. For example, you might have a $500 million underpayment, but the actual contravention will be, and potential civil penalty will be much lower. This is likely to significantly increase the value of those penalties. There's also a new criminal offence for an employer that dishonestly engages in a systematic pattern of underpaying employees, which Dee will be speaking about a bit later on. But I'll now hand over to Laura to talk about the vaccine rollout.
Great. Thanks, Matt. Thank you, Hedy, for your skilled camera work. Just something a little bit lighter. While 2020 was a bit of a train wreck in all respects for the world, one of the only good things that did emerge were the quality of the means, and that seems to be continuing for 2021. The COVID-19 vaccination rollout has been getting a lot of attention, and I think it will be an important turning point for Australia and other countries in dealing with COVID and hopefully progress a pathway towards resuming travel. Though I don't think it will quite be the end of working from home arrangements like the picture demonstrates. However, with Australia approving 2 vaccines currently and progressing with its rollout, and the government confirming for now that vaccination will not be mandatory, but instead has set out a staged approach to vaccine access with the aim of having everyone vaccinated by the end of October this year, various questions have been popping up like, even if the government won't make it mandatory, as an employer, can I require my employees to be vaccinated? And from the employee perspective, what if I'm concerned about returning to work because some of my co-workers have said they won't get vaccinated? Based on the media, employers have also been raising questions like, if they can't require employees to be vaccinated, will the business be liable if an employee is infected and then spreads COVID to their colleagues but also to customers? Australia hasn't been impacted by COVID to the extent many other countries have been. And while we have COVID-safe plans and some restrictions and controls still in place, people are largely back at the workplace and no longer required to work from home. So while the vaccine is exciting in terms of what it might mean for Australia and the rest of the world, it doesn't change employers' obligations regarding workplace health and safety. As we all hopefully already know, employers are required to ensure, so far as reasonably practicable, the health and safety of their workers while they are at work, as well as ensuring the health and safety of other persons is not put at risk from the work carried out by the business. So even if the government doesn't make it mandatory, can employers require it? The answer is, it depends. In terms of ensuring employees don't get COVID at work and what the vaccine means for this, Safe Work Australia has released a guidance statement. The statement provides that for most employers, it will not be reasonably practical to require employees to be vaccinated. What this means is whether it is lawful and reasonable to require employees to get the COVID vaccination will depend on the individual workplace and its risk exposure. For example, considerations will include any requirements for international travel, the impact of quarantine requirements, visa requirements for international travel, as other countries may make it a requirement for entry that a traveller is vaccinated, exposure to others from overseas, exposure to vulnerable people such as the healthcare and aged care sectors, which already many of which have vaccination requirements in relation to the flu, the effectiveness of an employer's other safety controls that are already in place, and importantly, how much COVID is actually in Australia going around the community. Whatever an employer's situation is, though, I think it's important to keep in mind that access to the vaccination is being staged with priority based on industry and vulnerability. So if your business is not an industry that has been prioritised, even if it is lawful and reasonable for you to direct and require vaccination, you won't be able to implement it anyway for some time, depending on the composition of your workforce. And even if everyone wants the vaccination, for a time there is going to be a mixture of vaccinated and unvaccinated people based on access. Even if a business cannot make getting a COVID vaccination a requirement, employers can still encourage and even incentivise people to get vaccinated. This is happening a lot in the US, and before presenting today, I had a bit of a look on Google to see what was going on with some American companies. And some like McDonald's and Trader Joe's are offering workers paid time off to get vaccinated, and others like Kroger and even some of the medical institutes are offering cash bonuses to employees who get vaccinated. One of the health companies in Texas is offering what they're calling a hope bonus and giving everyone who gets vaccinated $500. So it's interesting to see what they're putting in place. However, it will be important that employers are also ready to deal with any employee concern. As many of us will have been seeing in the media, people do have questions and concerns, including about, has the vaccine been tested enough and on a large enough sample of people? What are the risks for someone who might have a history of allergic reactions to vaccines? And should pregnant women receive the vaccine? There is a good chance that your employees may also have some questions, including the ones I've just mentioned. As employers, the best way to support employees, including those who may have questions and concerns, can really be summed up into 5 key actions. So firstly, stay informed, including by staying up to date on Health Department and Safe Work Australia guidance. Secondly, continue to identify and assess risk, as well as continue with the control and safety measures you already have in place, such as in relation to cleaning and, if applicable, social distancing. While there is effectively no COVID in the Australian community at the moment, when Australia does open its borders up eventually to the rest of the world, this risk will need to be continually reassessed. Thirdly, be clear and consistent with your communications about expectations regarding work and safety, including reminding and reassuring employees of the processes and controls that you have in place. Fourthly, respond to employee concerns, including, for example, if an employee says they won't feel safe at work because they know a colleague is not going to get that vaccination. In that situation, while that concern may, for the totality of what you've already got in place and the risk, may seem quite baseless, but it is important that it is still addressed. And to address it, it's important to understand what the concern actually is. And if you decide, well, really, there isn't anything to be concerned about, taking that as an opportunity to reiterate what steps you have got in place and provide reassurance. Lastly, remember that as supportive and helpful as an employer may want to be, they are not their employee's doctor. So should be encouraging employees to speak with their doctor if they do have specific concerns in terms of what does the vaccination mean for them, including, for example, I have a history of, and not saying hypothetically, I don't have a history of vaccine allergic reactions, but if someone says they have a history of allergic reactions, should I still get the vaccine? That's something that should be referred to their GP. Also, while COVID is still a pressing issue, the employment legal framework still applies. If requiring an employee to be vaccinated as part of a business's focus on health and safety, it is important that it is carefully managed, including in relation to decision making, communicating with employees, and addressing concerns, as employees can still make claims, including, for example, unfair dismissal or adverse action claims, workers' compensation claims if they develop a psychiatric injury from stress due to the requirement to get vaccinated, and discrimination claims, including if an employee is unable to be vaccinated for reasons such as pre-existing medical conditions or other medical exemptions, pregnancy, or even religious belief reasons. Whether any such claim would succeed is a different issue and is yet to be seen. There's been cases before the Fair Work Commission in relation to employees who have been dismissed for refusing the flu vaccination, but none that I'm aware of recently that have been fully tested on the merits of the claim, but instead have focused on preliminary matters. So, for example, one of them being Arnold and Good Start Early Learning from last year dealt with an employee who made an out-of-time unfair dismissal application, which was ultimately rejected. There was also Glover and Ozcare, which dealt with an unfair dismissal jurisdictional challenge, and the full matter is yet to be tested. However, both have resulted in the Commission making some helpful comments that can provide some guidance. For example, in the Arnold matter, when considering whether to extend time to allow Ms Arnold's claim to proceed, Deputy President Asbury made observations in relation to the merits of the claim. In that matter, Ms Arnold worked in a role that cared for children, and after her employer required employees to get a flu vaccination, refused, but the refusal was not based on medical grounds. In setting out the different factors at play in the matter, the Deputy President observed that prima facie, the respondent's policy is necessary to ensure that it meets its duty of care with respect to the children in its care, while balancing the needs of its employees who may have reasonable grounds to refuse to be vaccinated involving the circumstances of their health and/or medical conditions. It's also equally arguable that the applicant has unreasonably refused to comply with a lawful and reasonable direction which is necessary for her to comply with the inherent requirements of her position, which involves the provision of care to young children and infants. Whereas in the Glover matter, Ms. Glover, who was a care worker with direct client contact, declined a vaccination after employer also made it mandatory to get the flu vaccination. She stated medical grounds, but didn't provide the medical information requested by her employer. In making observations on the issue of making vaccination an inherent requirement of a position, Commissioner Hunt said that, in my view, each circumstance of the person's role is important to consider, and the workplace in which they work in determining whether an employer's decision to make a vaccination an inherent requirement of the role is a lawful and reasonable direction. Refusal of such may result in termination of employment regardless of the employee's reason, whether medical or based on religious grounds or simply the person being a conscientious objector. I should note that in both of those cases, the employers, when issuing the direction, also provided for a process for employees to refuse based on medical grounds. And when they did receive the refusals from those employees, did seek to engage with them to understand and address their concerns. So no doubt as the vaccine becomes more accessible and there are employers who may seek to make it a requirement, we're likely to see more cases pop up. More discussion on this topic, because we can go on all day about COVID vaccinations and lawful and reasonable directions. There's more information on Clayton Utts' website. Hayley and I published an Insights article last Thursday, and also Hilary Searing and Shay McCartney have released a safety podcast on the topic, details of which are set out on the slide. Otherwise, please feel free to shoot us an email and we can send a copy. Now, I'll hand you over to Dee to discuss compliance.
Thanks, Laura. As Hayley mentioned in opening, underpayments was a huge issue for employers in 2020, and it's not an issue that's going away anytime soon. There have been a number of recent examples of large Australian corporates disclosing that members of their workforce have been underpaid, which really demonstrates the challenges that are being faced by Australian employers in complying with a complicated system of Australian employment laws. We really empathise with our clients in this respect. It just cannot be that all such employers are intentionally underpaying their employees or engaging in wage theft. In fact, more often than not, there are extensive overpayments that are also made due to the same unintentional errors. A lot of businesses continue to look at their payroll systems for payroll compliance issues, and as they dig deeper, they seem to be uncovering more and more uncomfortable data about their payroll compliance. A lot of this has been relatively reactive. They have seen all of the media attention and the disclosures of other employers and wondered if they too also have a problem. We're now 10 years on from the introduction of modern awards, so we have a lot of corporates renewing their payroll systems. They're also having a look post the introduction of the annualised wage arrangements that came into place in early 2020, and it's through these processes that some of the unintentional issues are coming to the fore. A lot of big companies have not yet hit the media or hit the public domain, and there are some pretty significant potential underpayments that are still being investigated by employers, both large and small. For businesses that are just embarking on this journey, it can be a pretty challenging issue to face into as you start looking and uncovering more and more issues. Compliance with employment laws remains a challenge even for sophisticated employers, particularly in relation to award-covered employees. In a post-COVID world where you have employees working a lot more flexibly, many of them still working from home and outside the span of the 9 to 5, the issue of compliance is likely to be magnified, with employers needing to balance their strict legal obligations and the need to comply with underlying industrial instruments, both awards and enterprise agreements, with an increased demand from employees for flexibility. As an employer, it should be pretty clear what award covers you and your employees. But even such a basic and essential matter can be quite a technical and nuanced exercise. And as a result of this, we continue to see employers struggling with award compliance and misclassification of employees. It really should be no surprise then that we have employers struggling to ensure that their employees are paid appropriately. Although phrases such as wage theft are commonly thrown around in the Australian media to describe the actions of many Australian employers, we find this pretty misleading. In most cases, we have found that non-compliance is inadvertent, often arising from matters such as different interpretations of ambiguous provisions in modern awards, or pay rules not historically having been incorporated correctly into payroll systems. These issues obviously compound over time. And the reason we see so many overpayments, inadvertent overpayments, is the same reason we see so many inadvertent underpayments. It's really all the same issues. And it's not really a concerted campaign by employers to underpay their employees, but rather an underinvestment and a failure to recognise the significance of this. And because of the escalation of this issue in the public domain and the renewed rigour of our regulator, this whole underpayment issue is really taking on a life of its own. Now, it's important to note that there isn't actually a positive obligation to self-confess or self-report to the Ombudsman if you uncover compliance issues. But the Ombudsman has released correspondence and guidelines about when this is expected. The Ombudsman has also made clear that from an enforcement perspective, it is not afraid to litigate serious underpayments or serious contraventions of the Fair Work Act, and it will use its enforcement provisions to do this. However, they have said that they are taking a practical approach to self-reporting. For simple, isolated incidents over a short period of time, for example, less than 12 months, these types of issues don't need to be reported, provided that three things occur. First, you identify the issue and you rectify it quickly. 2, you advise your employees about the issue. And 3, you put in place measures to make sure that that particular issue doesn't occur in future. For all other more serious contraventions that don't fall within those guidelines, the Fair Work Ombudsman is strongly encouraging corporates to self-identify their compliance issues. That won't necessarily protect you from litigation if that's where you decide to go, if that's where the Fair Work Ombudsman decides to go. But it can open up other areas of consideration, such as enforceable undertakings being entered into as an alternative. As a general proposition, if an employer self-reports and cooperates with the Ombudsman may not seek to prosecute, or at least may be less likely to do so. There is this general sense that the Ombudsman is just out there harassing employers and suing everyone, and that's just really not the case. They only prosecute a very small number of employers, and it is usually those employers that have failed to cooperate or have failed to come back to the Ombudsman in any reasonable timeframe to talk about the issues that they have identified, to put forward their calculations, or to put forward a plan about how they're going to address the issues of non-compliance. In circumstances where the Fair Work Ombudsman does decide to prosecute, not only will they seek to have underpayments rectified, but they will often request that civil penalties will be imposed against the employer. The maximum civil penalty that can be imposed against a corporation who has contravened an award or the Fair Work Act by underpaying employees is $66,600 per breach. And for individuals involved in the contravention, the maximum penalties for them are $13,320 per breach. And this is applied per employee and per breach, so it's pretty easy to see how this can really add up. For example, if you're not correctly applying casual loadings or certain shift loadings, or you're not paying particular allowances to employees, all of these issues are separate breaches and could be charged as such. The Ombudsman has highlighted and been quite vocal about the fact that it will be looking at accessorial liability. So from a board and senior employee perspective, and even in fact third parties including lawyers, accountants and payroll providers who are contributing to payroll compliance and governance. They are all essentially in the mix, potentially. And the Ombudsman is not afraid to use the provisions in the Fair Work Act under Section 550 to bring them in and include them in the prosecution where they are involved in breaches and to seek penalties against them personally. So that is something from a board briefing perspective that we are seeing a lot of clients focus on and be quite proactive in relation to. We've seen enough media attention over the past 12 months to make sure that this issue stays front of mind at least the majority of the time. If the Ombudsman does contact your business, you really need to act quickly. And if you do that, it is much more likely that you'll be able to resolve the issue or end up with something like an enforceable undertaking rather than having to defend a prosecution. The question of whether an employer self-discloses or self-confesses to the Ombudsman is really a commercial decision rather than a legal one. The practical reality is that where an employer remediates but does not self-disclose, oftentimes an employee will at least go to their union or they may go to the Ombudsman themselves individually. And so self-disclosing can often be a piece around taking control of the narrative yourself. Even still, we do see circumstances where employers do decide not to self-disclose to the Ombudsman. Just one other thing to be aware of for some large corporates are the market disclosure requirements as well. So while you may have the Ombudsman knocking on your door asking why you didn't self-confess or self-disclose sooner, some corporates will also have those market reporting obligations as well. So it's just something to be aware of. The last thing I'd like to touch on is the introduction of the wage theft reforms, both across states and as currently being contemplated at a federal level. In terms of the status of reforms across the country, as we've alluded to earlier, in Victoria and Queensland, legislation has already been passed, and we will see in those states that there will be criminal penalties. Those criminal penalties are, however, limited to areas where there is a dishonest withholding of wages. If there is a dishonest withholding of wages or other entitlements, you could end up as an individual, a director, for example, with up to 10 years jail time. We'll have to see how serious a contravention there would have to be for that type of penalty to be imposed. The other angle is the significant fines that are involved. I've highlighted some of those up on the PowerPoint. Federal government has also made a commitment to legislating criminal penalties for deliberate and systemic underpayments, as Matt alluded to. Given the comprehensive and penal consequences in the states, there is a question of the federal government creating a national standard, which would obviously imply over the top of the provisions that have already been put in place in the states. It is really employers who are knowingly, deliberately and systematically underpaying their employees who these laws are targeted at and who the Fair Work Ombudsman is intent on pursuing. Modern day employers now have a well-funded ombudsman that is active, and they also have these legislative obligations that criminalise underpayments. Previously, you would have had claims from unions that would have been processed on behalf of individual employees, and now we also have class actions. We're seeing an increase of employment-related class actions for the first time in matters such as misclassification of employees and underpayment of wages. This is a domain traditionally litigated by unions on behalf of their members as a group. So we have the Fair Work Ombudsman very actively and unashamedly prosecuting and then holding employers to account, and now we also have class actions to contend with. We don't know quite how this is all going to play out, but certainly a space that you should watch in 2021.
And back. Now, I'd like to actually encourage, if anyone would like some questions to be answered, to hand over to my panel again on what are the practical things. Sometimes it does feel a little overwhelming that just coping with the post-COVID world is enough, but adding to that some of the regulatory IR reform and employment law compliance matters that arise does seem to be overwhelming. I would like to start with some questions about casuals. As long as I've been practicing employment law, which sadly is coming up almost 30 years, casuals have been a continual reinvented legal construct. A quarter of Australia's workforce, depending upon statistics and time, will be casual. The impact frequently comes with instructions that we might receive that people want to be casual. So what happens then? I can't get them to convert to permanent part-time. With the High Court looking at that double-dipping component that I referred to earlier in relation to Rosato, I'd like to ask you, Matt, what do you think employers should do in preparation for the passing of the bill, the recharacterisation of casuals, and that potential legal compliance piece that we're talking about?
Well, I think consistent with what you're saying, Heidi, about this having been an issue for 30 years or perhaps even longer, I don't think we should assume that the issues with casuals will go away as a result of the bill being passed. The new provisions that it introduces about the definition of casuals and offsetting casual loading and putting some more processes in place about casual conversion to try and provide some more certainty to employers, that'll all be useful. But I think it will create new disputes about how those provisions apply. Similarly, whatever the High Court decides in Rosato, it may find that the casual loading is available to set off those leave entitlements. Even if it does that, there'll still be a need to understand as an employer what your risks are and how you've been dealing with your employees. There are lots of avenues to dealing with those risks that might be created by the High Court deciding in a particular way or this bill being passed. But as an employer, I think it's still really important to be taking proactive steps now to understand how you've been engaging casuals, whether you do have long-term casuals that have been working stable patterns of work for an extended period, and looking closely at those higher risk groups of employees, and so that you're in a position to work out what the best strategy is for you moving forward, depending on how all of these developments play out.
So really, I think that for an employer looking at where casual employment might go into the future, there's going to be those regular patterns of work and engagement that are going to make it increasingly harder to call them casual employees. It might be fair to say we need to watch more closely as legislation is passed as to compliance, because the impact that historically might have occurred where you have an employee who wants to remain casual, but you are rostering them and treating them as a permanent part-time employee might trigger some compliance issues that you will need to address.
I think just another point on that, the other changes that are proposed in the Omnibus Bill about a flexi part-time arrangement, that can overlap in practice with what a casual looks like. And I think that the possibility that employees could be engaged in under that sort of flexi part-time arrangement is something that I think employers should be looking at, and I think it's something that could be a significant change and could be something that's quite attractive to employers if you can guarantee, say, on the way the bill's currently structured, 16 hours per week for people, and you then don't have to pay them overtime for additional hours up to 38, and you also don't have to provide them with the casual loading. That might be financially an attractive option for some employers.
Is that what you describe as the biggest practical impact, do you think, of the bill, Matt?
I think it's hard to know what the biggest practical impact will be. Maybe part of that will depend on what happens in Rosato and whether the offsetting arrangement that's in the bill is any different to how the High Court decides that case. But yeah, I think the flexi part-time concept and how that's dealt with in the bill, including the possibility for it to be expanded by regulation in future, is something that could have quite far-reaching consequences. It's also a different style of regulation than what we've seen over the life of the Fair Work Act to date. It's the Parliament directly intervening in the content of awards by regulation, which will mean that it's much easier for the government to change employment conditions and directly control them, rather than handing off responsibility for that to the Commission.
Do we think it'll get passed? The ACTU called for everything to be stopped pending the Attorney-General's return to work and closing out the issues that are the subject of an inquiry.
Well, I think the statements that were made by the crossbench senators yesterday were that they didn't see the Attorney-General's absence from Parliament or the current issues as being in any way relevant to the passage of the bill. I think it sounded like from their media statements that they were keeping their cards pretty close to their chest. I think One Nation seemed to be looking for more pro-employer amendments to be made to the bill. That might be weakening some of the casual conversion processes. It's unclear where Centre Alliance will end up, or what other political objectives they might have in this process.
Thank you, Matt. Well, it's a watch this space on the bill, but we are hoping that we'll get some clarity for everyone on the ongoing impact, particularly of flexible work practices and casuals, and how we might be able to approach these compliance matters moving forward. Laura, what do you think the COVID vaccine rollout is going to do for that working from home impact and the consequences for employers managing the ongoing flexibilities in relation to how work is performed?
At this stage, I think practically very little. As I've mentioned, Australia has done quite well in coming through the pandemic, and while there are plenty of people still working from home, my understanding is a lot of it is part of choice, but also employers taking the opportunities in terms of learning about how employees can work from home. Is it desirable? Is it actually workable? And for some employers, yes. And there's others who are already doing plenty of work from home, like in the IT industry, whereas others have discovered, well, it doesn't actually work for them, so not so much. So adding a vaccination into the mix, I don't think will change it terribly much, because I think it's actually by the stage with how we've all evolved in terms of how we work, it's a separate issue altogether in terms of ensuring compliance and being able to support, supervise, ensure people are actually performing work and are supported in doing so. However, with the vaccine coming in, it can mean for perhaps there may still be some people who are working from home due to concerns about their own medical vulnerability, and it might provide an extra level of reassurance and safety control to allow them to come back in as well.
There's been an incredible focus on the mandatory nature of no jab, no job, and whilst we've discussed that there is Safe Work Australia guidance, that it is voluntary. One of the biggest questions that we keep being asked is when can an employer roll out the vaccine, and how will they be able to implement it like a flu jab, and is this likely to be possible? Do you have any practical thoughts about the accessibility to vaccine and the employer's ability to do so?
Well, I think it will depend on when people in general can get access to it. So perhaps limited now, but reassessing later on in the year when it can be available to anyone who wants it. I think that will be a real possibility in terms of the practical ability if you have assessed that it would be an appropriate, lawful and reasonable step for your workplace to be able to actually implement it. In terms of what that means now and looking forward into the future, and if you are in an industry where you think this might be actually appropriate, for example, you may already have it as a requirement for employees to get the flu vaccination. It can be making sure that you're up to speed on what Safe Work Australia has been providing, what the health department has been providing, but taking this as an opportunity to be reassessing your risk profile altogether, to make sure that you can have clear communications in place around any direction that you may wish to provide to employees, so that you're ready to be able to do so when you actually can practically implement it, but you're ready for any sort of concerns, questions, that type of thing.
There's a lot being said about the impact of when Australians might be able to travel overseas and what conditions of vaccination might apply. Are there any industries that you think will get closer to the ability to mandate and or lawfully and reasonably direct the impact of vaccine being a requirement to perform a risk minimisation of duties in the workplace?
I think so, and it will depend on how successful I think other countries are as well in terms of managing COVID. But some industries that immediately will come to mind are anyone in the like travel industry in terms of airline travel, that type of thing. But I know there's been different groups popping up and saying, well, that's all well and good that the airline staff and quarantine staff, that those people get it. But what about people in retail who will work in tourist hotspots that will be getting a lot of international travellers in? Aren't they a priority in that as well? So I think it really is a wait and see, because it's not just on how Australia is managing it, but also, who are we going to open up to? How have they managed it? And also overall, how effective the vaccine has been in terms of preventing transmission and sickness.
Thank you, Laura.
I should say I'm very keen to start travelling. Australia is lovely, but
I think there's many in that boat, and I have heard everything from Qantas announcing July and some medical practitioners suggesting that it might be 2023 and beyond. So we will again watch this space and see how the rest of the world plus Australia in quarantine and restrictions impact upon the safety, at least on our shores. D, I have never heard so many payroll systems being described as moribund and ineffective for the impact of the workplace relations regulatory environment. As you said, these laws and modern awards have been in place for now over 10 years. What practical tips would you give employers looking at their payroll system and trying to ensure that compliance piece is properly addressed?
I think there's a couple of things. One that should stay front of mind is that you need to continue monitoring variations to modern awards, including wage increases, and to make sure that you make any necessary amendments to ensure compliance with those. Another thing that applies more broadly, even for those that don't have employees covered by awards and have industrial enterprise agreements instead, is that you should really review your payrolls in your payroll systems to ensure that they are accurate, and to also update those if there's any concerns there. So they're my two key tips.
I think we've captured quite a few of the questions that have come in those questions, but one additional question: where would you guide people to go to find a list of the reviewed and updated awards?
Go to the Fair Work Commission website, and if you have any difficulty finding those, you can always reach out to us and we can help you out with that too. Excellent.
Unless there are any other questions, or from my fantastic panel, any other contributions you would like to share today about your respective topics, I must say there is a lot that is going to happen in 2021. As businesses will continue to juggle, we are seeing the enormous impact of what getting back to business means. Commencing negotiations, increasing focus on compliance, and obviously, as I mentioned from the outset, the increased focus on workplace culture, communications in the workplace, and the overriding need to ensure that there are good policies and procedures and appropriate steps for addressing and dealing with workplace behaviour. On your course and your path for 2021, we will be with you and wish you the very best as you follow through and map the ongoing matters that we have addressed today. Thank you very much for joining us.